Welcome to the first ever Securities Arbitration Commentator podcast. I'm the president of Securities Arbitration Commentator, Richard Ryder. SAC strives to be a pro-arbitration, party-neutral force in arbitration. What we hope to accomplish in this and subsequent podcasts is to stimulate thinking about topics and issues of interest in securities arbitration, and to do so by bringing together people who are knowledgeable about and influential in the securities arbitration industry in order to discuss these issues and offer their personal insights and opinions. Listeners should keep in mind that while our guests work for and represent various firms and organizations, their views as expressed in this podcast are not necessarily the views of those organizations. To introduce our guest speakers and lead them in today's discussion, we've invited George H. Friedman to be moderator. George is an ADR consultant and SAC Board of Editors member. He retired in 2013 as FINRA's Executive Vice President and Director of Arbitration, a position held from 1998. Before that, he held a variety of positions of responsibility at the American Arbitration Association, most recently as Senior Vice President from 1994 to 1998. For the last 19 years, George has been an adjunct professor of law at Fordham Law School teaching arbitration. He serves as chairman of the board of directors of Arbitration Resolution Services, Inc., and is also the principal of George H. Friedman Consulting, LLC. George holds a JD from Rutgers Law School, is admitted to several bars, and is a certified regulatory and compliance professional. George, thank you for being here today.
Thank you, Rick. And my mom would want to add that I talked at the age of 10 months early on. Thank you all for joining us today. Let me dispense with the legalese, which I will not read, but basically don't steal this, and people are speaking for themselves. So let's go to the introduction. Dodd-Frank authorizes the SEC to ban or impose conditions on the use of pre-dispute arbitration agreements in customer broker agreements if the SEC finds that such prohibition, imposition of conditions, or limitations are in the public interest or for the protection of investors. As we all know, pre-dispute arbitration agreements have been used for years in the securities industry for not only investor-broker contracts, but also disputes within and among industry members. So in our podcast, which will be very fast-paced, it's going to run about 40 to 45 minutes, the panel will discuss what might happen if the SEC were to actually ban pre-dispute arbitration agreements in customer broker contracts. We're not going to debate the if, but we're going to make believe that at some future point, the Commission actually went ahead and banned the use of pre-dispute arbitration agreements in customer broker contracts. Now, we will use the term PDAAs as indicated on the slide, just so we don't take longer than 45 minutes. Now, let me introduce our distinguished panel here. To begin with, we have Mike Alford. Mike's in the upper right corner there. Mike is a Senior VP and Deputy General Counsel with Raymond James Financial down in St. Petersburg, Florida. He's been active in securities arbitration litigation, both as a practitioner and an industry speaker for more than 25 years, or to make it sound like a longer time, a quarter of a century. He's on SIFA's National Arbitration and Litigation Committee. He's handled cases at FINRA and the National Futures Association, and currently serves on the SIFMA Compliance and Legal Executive Committee, and recently got appointed to the editorial board of the Securities Arbitration Commentator. Melanie Cherdack, down on the bottom right corner, is of counsel at the Miami office of Genovese, Joblove, and Battista. Before this, she worked at Payne Webber, which of course is now UBS. She's been a FINRA arbitrator for about 20 years, an NFA arbitrator, has been on many arbitrations as a panel member or chair, and she primarily represents individuals who bring securities arbitrations. And then last but not least is my friend David Robbins. David is a partner in the New York firm of Kaufmann, Gildin, and Robbins, specializing in commercial arbitration and mediation. Represents all sorts of parties, investors, brokers, and firms. He's been an arbitrator for many, many years, and for a gazillion years ran the PLI Securities Arbitration program. Okay, here are some of the questions we're going to be talking about today. I'll pause for a minute to let you take a look. Now, to get to these questions, we have a vehicle. We have 4 major discussion topics as indicated here. We'll begin with a background on Dodd-Frank and what it has to say about consumer arbitration. The panel will then react. We'll then look to what's going to happen or what we think might happen with the FINRA Arbitration Forum. And then we're going to close with my favorite part, which is where the panelists predict will be 5 years from now. It's my favorite part because people can disagree with you, but they cannot definitively say you're wrong unless they claim to be from the future, which immediately diminishes their credibility with the audience. So those are the 4 topics that will help us get to the issues that we've identified. Now, beginning with the first one, first major question. Background on Dodd-Frank and customer arbitration. So we're going to begin with some basics, the first of which is, well, what does it say? For that, I'm going to call myself. George, what does Dodd-Frank say about customer arbitration? Well, let's take a look. Section 921A of this very, very, very long statute amends the Securities Exchange Act of 34 and the Investment Advisors Act of 40 to authorize, but not require, the italics, by the way, are not in the statute, I added them, does not require the SEC, but authorizes the Commission to do certain things. One is the Commission can limit or prohibit the use of PDAAs arising out of the federal securities laws or the rules and regulations are under any SRO rules. So one is prohibit or limit. The next part, however, adds another one, which is impose conditions. I think it's just sloppy drafting, but so it's allowed to either prohibit, now they can also impose conditions or limitations if they find doing so is in the public interest or for the protection of investors. All right, so to begin with, it's permissive, and again, I think it allows a third thing besides prohibiting or limiting, that they can impose conditions as well. That is what the statute says. I'm not going to pause for reactions just yet because the statute speaks for itself. I'd like to get on to the next question and stop my monologue here. So the first question is, must the Commission do a study first? Again, looking at the language, you know, it says they can take certain steps if they find that it's in the interest of protecting the investing public. So let me start with Mike Alford. Mike, do you think the Commission has to do a study before it does anything?
Thanks, George. You know, looking at the language which you've just gone through, obviously there is no explicit requirement that any study be undertaken in advance of any decision or action by the Commission. And I think what's informative is if we contrast that with Section 1028A of Dodd-Frank, in which Congress mandated that the Consumer Financial Protection Bureau, or the CFPB, conduct a study and provide a report on pre-dispute arbitration agreements in connection with consumer financial products and services such as credit cards, bank accounts, checking accounts, and the like. And in fact, if you look online, you'll see that a report, at least a preliminary report, has been published by the CFPB as of last December. I would tell you that it's difficult to imagine how the Commission would determine whether proposed action is in order or in the public interest in the absence of a study. I think politically it would be astute and called for by way of Commission action. But other than that, the short answer is no, there's no absolute requirement. I can't imagine the Commission not moving forward without some type of a study. And if you look at correspondence by Mary Jo White to Senator Franken and others back in 2013. She talks there explicitly about receiving feedback in response to the Commission's release in March of 13, and that her staff is actively looking at the letter responses.
I think I agree. Not that I'm going to weigh in agreeing or disagreeing with every comment, but it seems to be implied that they would have to do a study. Also, I think politically, if the Commission said, you know what, without doing a study, if they said, you know what, we've been oversighting the securities arbitration system these many years, and we just realized it's completely unfair and changes need to be made, that's untenable, I would think. I obviously don't speak for the Commission. We didn't say that, but it goes without saying. But it certainly seems to be implied. Well, here's a more provocative question. So the premise of our program here, our podcast here today, is suppose the Commission banned pre-dispute arbitration agreements. So avoiding the if question, assuming they did, do you think they could make it retroactive? In other words, could the Commission say pre-dispute arbitration agreements are out, any agreements that are in existence are nullified and cannot be enforced or used? David, any comments on that?
Well, George, I'm going to plead the fifth. In that a ruling that retroactively invalidates contracts such as PDAAs could be subject to challenge based on the impermissible governmental taking, absent a compelling governmental interest. You know, the Fifth Amendment's taking clause states, no person shall be deprived of life, liberty, or property without due process of law. So absent a compelling governmental interest, I can't see such a ruling being applied retroactively, and I don't see any compelling interest to do so.
And there have been a couple of cases that I've seen wearing my law professor hat, which would seem, on retroactivity, would seem to say if Congress meant something to be retroactive, they would say it. And it's certainly Dodd-Frank doesn't say that. Now, I said my own view is that there was some sloppy drafting, but it would also create an issue that probably doesn't need to be there, which is if it were made retroactive, I think it would spawn challenges. There's no question about it.
It would be such a sea change, George, that to then apply it retroactively would really muddy the waters.
Which, by the way, that would not stop FINRA from saying that may be, but the forum will not be available for pre-dispute arbitration agreements. That's been done before. It's just that's not retroactive. It's FINRA saying, good luck, but we're not taking cases under such clauses anymore. All right, let's move on to our next topic, which are reactions from the panel. The first would be, again, we're assuming the Commission bans pre-dispute arbitration agreements. So, what would happen? So, Melanie, let's get you involved here. And again, I know you don't speak for all customers, but what's your take on whether customers would use arbitration on a voluntary post-dispute basis?
Well, I think my take is that some would and some wouldn't, and it would depend on a number of factors. It's my belief that in the past 10 to 15 years that among the claimants bar, there's become a kind of a negative perception of FINRA arbitration as the be-all and end-all of the dispute resolution process, in part because there's just an uncertain outcome in the case, and you might think you have a great case and you've proven everything at the hearing, and you walk out and you get a piece of paper 30 days later that says, you get nothing, claimant gets nothing, and you're sitting there scratching your head and you're thinking, geez, if I was in court with this case, I'm reasonably certain I would have gotten something. I think, that's one factor. I think the second factor that there's been negative perception of FINRA arbitration is that there's been a spate of some bad discovery rulings because sometimes, for example, you have non-lawyers making them, or you have, someone that doesn't quite understand the process or the product or the theory of your case, and, there's no recourse and there's no right of appeal. There's limited subpoena and discovery power in FINRA arbitration. There's, everybody knows there's no depositions, and so it's very narrow what you can find out as a claimant. And I think there's a common belief among certain claimants' lawyers that there's some industry bias on behalf of some of the arbitrators who are fearful that they might not get chosen again by the respondents' counsel, and there's a little push by those people maybe not to make such a claimant-friendly award. I'm not speaking on behalf of everybody, but I think that some of these are widely held negative perceptions, and I think because of that, many claimants' attorneys might opt for litigating in court for these reasons, that there's more certainty of the legal rulings, that there's a right to appeal, there's broader discovery, and, I think significantly, and this may be the number one reason, the transparency of the process. No one quite is 100% sure how arbitrators get appointed to a case or how the lists get generated, and so if you file a case in court, you know how a judge is going to get appointed. And there generally is going to be no last-minute replacement of that decision maker. And so there's a great transparency of the process, and I think that's, a factor that often gets overlooked. But, of course, all this comes at a cost. It's expensive. Litigation goes on for years sometimes. Trials cost a lot of money. So, taking those other factors into account, the short answer is who do I think might arbitrate and who do I think might litigate? I think large damage cases will it get litigated where the upside is great, and so a lawyer in a law firm can afford to invest a lot in a case. The second category would be cases where there's a clear right to a fee, like a case where there's a clear statutory right to an attorney's fee if you win and you feel like you have all the facts that are going to enable you to win the case. The third category would be strict liability cases. Well, they might be smaller cases, but you can win them on summary judgment, things like an unregistered broker, unregistered security. I think those cases will all go to court. And so that would leave for FINRA, as I see it, like I call it the land of the misfits. I think FINRA is going to get small claims cases or cases where there's maybe a technical legal problem and the case is only gone on the equities, like a statute of limitations issue or a jurisdictional venue issue, or a case where there's no clear-cut legal liability, but equitably the case cries out for a ruling on behalf of the claimant. And the third category, I think, are cases where a quick resolution and a finite resolution is necessary. If we have somebody that's in dire need of the money, you have an elderly or an infirm case. But I think that's the likely scenario if there is a choice to voluntary post-dispute arbitration.
And again, another caveat, I know Mike does not speak for the industry or any institution, but you're in the industry. What's your take or your personal view about whether the securities industry would use arbitration on the same basis? And you could also address the follow-up, which is, would it depend on the size of the claim?
Well, it's interesting, George, because some of the same sentiment that Melanie has heard on the investor side of the table, we hear being discussed on the industry side as well, specifically a yearning, if you will, for the days of motions to dismiss and dispositive rulings at the pretrial stage, the ability to hold the opponent's feet to the fire on rules of evidence, et cetera. So I think to some extent there's probably a large number of industry representatives who would welcome an opportunity to take some of these cases, particularly some of the larger cases, back into court, into litigation, again, in our alternative reality where the SEC has banned all PDAAs. Now, as far as the securities industry goes, generally, I would tell you that the practitioners believe arbitration continues to offer an efficient and fair method of resolving business and commercial disputes, and it's my opinion that the industry would be willing to participate on a voluntary post-dispute basis with one important proviso, and that is that the decision to arbitrate, regardless of when it's made in the process, be mutual or that the agreement be bilateral. What the industry is particularly concerned about is any proposal that would grant the unilateral right for investors to choose arbitration on a post-dispute basis without the consent of the firms. This unfettered right to strategically forum shop, and you heard Melanie kind of walk through it. I believe she said, if my case is strong on the law, then I'm happy to go to court. If I've got a, quote, technical legal problem and I want to just argue the equities, then I'm more likely to go to arbitration. And that kind of reminds me of the old joke: if you're strong on the law, pound the law. If you're strong on the facts, pound the facts. If you're strong on neither, pound the table.
Well, I'll give everyone a chance to talk about Rule 12-200 a bit later, which is the one that allows the investor to insist on arbitration with the brokerage firm. We've skirted around another issue, which is litigation. My personal view is it stinks, but is it that bad? Is it really that bad to litigate? Now, David, you've been on all sides of the coin here, so let's start with you. Any views on that?
Yeah, well, George, because I'm an advocate of the arbitration process, it doesn't mean that improvements aren't necessary. They are. We'll be talking about that in a few minutes. That said, litigation is not an equitable forum. Arbitration is. Many customers, I think, would forego litigation because of the damages alleged. Last week I asked FINRA, what's the percentage of cases brought now that are under $100,000? And that's 16%. So, and I think it was a little higher last year. So I don't see any attorney taking a case to court that's under $100,000. I think the time factors of motion practice and discovery, along with just the intrusive nature of litigation discovery, will discourage customer claims from being litigated. I think the jurors, who unlike arbitrators are not volunteers, are probably more empathetic to sympathetic investors. They're less receptive to Wall Street than FINRA public and non-public arbitrators, who are, by and large, professionals with many years of experience and who maybe have some built-in hindsight bias. Jurors may be less sympathetic to upper middle class and wealthy investors who have cases of merit, mainly product cases that have been heard in arbitration the past few years. And this year the Second Circuit Court of Appeals, one in New York, came forth with a bright line definition of who a customer is. FINRA doesn't define the term, but I think other courts will pick up on that. And as a result, I think more Ponzi cases will be compelled to litigation, prompting customer attorneys to only take big-ticket cases that don't have that soft underbelly of statute of limitations issues that often happen in Ponzi cases. So is litigation really that bad? No, but the bottom line is that it is a form of law, not a forum of equity.
Okay, thank you. The next group of questions concern, well, what will happen? Again, we're assuming the SEC has banned pre-dispute arbitration agreements. So I have a series of questions for us to ponder about the FINRA forum and its rules. So the first one is, well, would the forum survive? And then we'll get into other things like what changes are needed. George, let me ask you a question. Would it survive? I think Melanie actually answered this the way I would, which is I think it would survive. It would become a smaller claims forum for claims under 100,000 or 50. We can pick a number. I mean, to me, 100,000 is a lot of money if it's mine. But it would be a smaller forum, and I think it would be smaller in general because the caseloads would decline in a voluntary post-dispute world. I agree with the comments made before that larger cases would end up probably in court or competitors like AAA or JAMS. I know FINRA has made efforts via a large complex case pilot to capture larger cases, but in my view, there's a view I held when I was at FINRA, and I still hold there's a perception that for larger cases, that FINRA is a forum for smaller cases. When you get to really large ones, it's not as well suited. That may change, but that is the view now. Now, as to my comment that the forum would get smaller, that the caseloads would decline, I turn to a comment made by Linda Feinberg, who is retiring as president of FINRA Dispute Resolution, but about 4 years ago at an SEC Investor Advisory Committee meeting, that question came up, and I'll just read the quote. She expressed concern that if small claims would came to arbitration while larger claims were pursued in court, FINRA's arbitration forum would lose money as it relies on the filing fees and costs of the larger claims to fund its operations. So I do think it would be a smaller forum. And, the reason I think it'll survive is there is going to be a need for a forum. About a third of the cases that FINRA gets now are not consumer or customer cases. They're industry cases, most predominantly employment. And, you want the forum there if there's a fire. As I've written a couple of times, when there's a fire and you break the glass, you want to be sure there's a fire brigade that's going to be around to respond. My last comment in terms of changes they would need to make, clearly it's not economical to do really small cases through in-person hearings with people, using paper back and forth and going somewhere for hearing. And I do think, and I know FINRA is investing in the technology, that some class of cases, some typically smaller, would have to be done online to save time and money. I mean, that's one change I think they're definitely going to have to make. So that's, it'll survive. It'll be different. It'll be a smaller forum, no question about it, and would have to make some changes. Any other views by panelists as to what changes they might have to make? David, any views on that?
No. Actually, the changes in the process. Yes, I'm sorry. Yes. I was thinking while you were talking how I could summarize the changes. And I think it's this way. And they're down to 5. Greater ability for parties to select their own arbitrators, whether they're FINRA arbitrators or not, and pay the arbitrators more than FINRA honorarium. Big criticism that parties have on both sides is the arbitrators. Their age, they're sitting on too many cases, the repetitive nature of them. I think that if FINRA did what the AAA does, which allows parties to select their own arbitrators, and which FINRA does for large and complex cases under those rules, I think that would go a long way to improve the process. I think also if there's a greater reduction of the director and case administrator involvement in cases, permitting more transparency between the parties and the panel, that would be a great improvement. An example is making mandatory direct communication with the chairs, knowing that by agreeing to assume the role as a chair, they will be called upon to consider and decide pre-hearing issues. The FINRA now has a voluntary direct communication rule, which in probably 98% of cases are not followed. When direct communication is followed, it just works beautifully. Parties love it. And I guess my third and last one is a point that I discussed with the new president of PIABA, Joe Pfeiffer, and he's in agreement on this, making arbitrator training on substantive issues mandatory, and have arbitrators be required to take podcasts and attend podcasts like this one on special educational subjects with subjects that are put together by PIABA and SIFMA, not by FINRA. Those, I think, would be some just great improvements.
Thank you. Mike, do you have any thoughts on that?
Yeah, George, just to follow up on David's comments, I think that the quality of the arbitrator pool generally is a legitimate and oft-expressed concern of all sides of this discussion. And I think that that's something that if FINRA is to, at least the dispute resolution side, is to continue and thrive, it really needs to take a look at that. And perhaps with the new administration coming in, we'll see a renewed and greater willingness to really drill down on that and listen to the feedback, not only from the claimants bar, but from the industry bar as well. A couple of other, points on the wish list to follow up on David's would be taking a look at not necessarily becoming another JAMS or AAA, but moving more to that model with a higher paid, more sophisticated group of arbitrators available to the parties. I think a greater ability to manage the selection process would be greatly needed or greatly appreciated as well. And when I look at that, I sort of look as a model for that the large and complex pilot program, which Raymond James is actually a part of, and we've been very satisfied so far to the limited extent we've been able to participate in that.
Okay, thanks. Let me move to the second question, and to keep us moving here, let me first move to what it actually says. We've talked about Rule 12-200, and it's a rather short and simple rule, but essentially it says, obviously if there's a pre-dispute agreement, that would not be the case in our future world that we're talking about here, but the rule says if the customer wants to arbitrate, the firm has to. And I'm going to put aside a debate on what's a customer. The courts have been struggling with that. My personal view is FINRA should clear this up. I've written an article to that effect. But the question is, and I'll ask the panelists, and I'm going to call on a couple of them to be succinct so we can keep moving, but should this rule exist? In other words, the SEC bans pre-dispute agreements, so this rule, or this part of it that I'm pointing to here, part number 2, should the customer still have the unilateral right to require arbitration with the firm? And we've heard from a couple of the panelists already on this, but I'll ask Mike and then Melanie to succinctly weigh in on this. So let me start with Mike. Should the rule survive in its present form? Again, the first part will be gone. We're assuming pre-dispute agreements are gone. So should investors have the right to require arbitration?
I would say that in the absence of a voluntary pre-dispute arbitration agreement or a decision that is mutual at the time the dispute arrives, no.
Okay. Melanie?
And I think that you all could probably anticipate that I wouldn't agree with that. I think the problem with having a mutual agreement is that in most cases, you're going to have two people with diametrically opposed views on whether a case belongs in arbitration or in court, just based upon kind of the comments that Mike and I made at the beginning of the podcast. So I think it would render the rule, in my opinion, completely useless if it required a mutuality of that agreement. I think, if the purpose of Dodd-Frank is to make a forum that is more helpful to investors, more accessible to investors, more investor friendly, and that's my reading of what Dodd-Frank says, you would have to let the claimant decide which forum to be in. And, I think by at least making it not a mandatory thing, it opens up a whole host of choices. But again, without a mutual agreement, with a mutual agreement, I think it's unfair to the claimant.
Now, David, I'm going to put you on the spot a bit. You weighed in a little bit before on improvements, but that might be needed. But again, now focusing on this world where Rule 12-200 may or may not be around. What if FINRA needed to compete? What would they need to do here? What changes would they need to attract both sides?
As I said before, George, the parties need to feel that they're participants to the process. They need to feel that the administrators do not have a central role in the process. They need to feel and really know that they have a hand in the selection of arbitrators who have no ties to anyone except to this particular case, that they're not sitting on 15, 20 other cases. I see that often, by the way. When we are selecting arbitrators, FINRA tells us the other cases that these proposed arbitrators are sitting on, and it floors me. And why there should be a limit to the number of cases they sit on is because it's very hard to schedule hearings when the arbitrator is on so many other cases. I know there's room for improvement. FINRA put together a spectacular special task force. People from all over the country that are on it, that are looking into ways to improve the process. I think it really speaks wonderfully of Linda Feinberg in having this idea of putting this together. They've started to meet, they've started to question people, and they're questioning people throughout the country. What can we do to improve the process? So I think each year you see the evolution of the process. I was involved in it when it was voluntary, when I was a director of arbitration at the American Stock Exchange in the mid-'80s. And then once it became mandatory, attorneys started being involved in the process, and the process improved tremendously. I think every year it improves. So I'm optimistic about the process, especially with this new task force.
Thank you. And to the last question, last bullet point here, and we'll try to be succinct. There's a Rule 2268, I'll show it in a second, that governs the content and placement of arbitration agreements. So our question is, well, if the commission were to ban pre-dispute agreements, would this rule still be around? Would it still be necessary? And let's take a look at the rule. Basically, the first part I'm pointing to here in A requires certain requirements about the arbitration clause, where it should be, what it should say. I did not quote the entire rule, but it's a very long section that I called the Miranda warning that says, hey, look, there's an arbitration agreement here, and if you're agreeing, understand, you're losing your right to go to court, there's limited appeal, so on and so forth. Then in B1, there's a requirement of warning people that the arbitration agreement is there. And then I just jumped ahead to D, which I think is important. This is what caused this is behind the Schwab dispute that took place with FINRA. But this section here says, if you have an arbitration agreement, it can and can't do certain things. So the question is, okay, if pre-dispute arbitration agreements are out, then you need a rule here governing post-dispute arbitration agreements. I'll start with I'll ask myself the question. I think yes. I think the rule would still be there in some form. Obviously, it wouldn't refer to pre-dispute agreements, but I think in such a world where pre-dispute agreements are banned, FINRA would still have a rule that essentially said, look, if you're going to offer arbitration on a voluntary basis, you, the firm, have to abide by the following investor protection steps. For example, you have to warn people what they're getting involved in. You can't hide the clause. Maybe they're going to require that the investors separately click or sign it. There may be questions about timing, when you can offer it, and other procedural safeguards, like, if it's even on a voluntary basis, you can't eliminate things like punitive damages. So I do think there would be a rule, it wouldn't look exactly like this, but some rule to protect investors, even in a voluntary post-dispute world. Any of the panelists have thoughts on this? Or have I been so erudite that there's no question that it's going to happen that way? Okay. Now, I'd like to close. This is, again, my favorite part of the program because, as I said, people can disagree. They can't say you're wrong. I'm going to go last, and no one can say I'm wrong. But I'll go in alphabetical order. And the question is, at a high level, where do you think we're going to be 5 years from now, given all the things that are going on? And again, in alphabetical order, Mike gets the first crack at the question here.
Thanks, George. Well, I certainly think that in the next 5 years that the SEC will have indeed embarked on its study of fairness of pre-dispute arbitration agreements in the securities industry context. I do not believe that the debate will be concluded by that point, but I think we'll be a bit farther down the road. I think that in an effort to address concerns from its constituents on both sides of the discussion, that FINRA will take a hard look at the quality of the arbitrator pool and begin to apply more rigorous evaluation of its ranks. And I think we'll, through the task force, perhaps take some of these recommendations that are being made now into account. And I think that an effort to address arbitrator comp will be forthcoming. So we have something either closer to the AAA JAMS model, or as you have talked about earlier in the podcast, perhaps it becomes a small claims court.
Thank you. Melanie?
Well, maybe I have a little Pollyanna in me, but I think that maybe we're going to have a choice in the future. I think that given that this topic has become such a hot button, that claimants will be given the choice as to whether to arbitrate or litigate. And, going to kind of the second prong of that, what's going to happen with FINRA, I agree with Mr. Alford and Dave Robbins, and I think everyone. FINRA is a very dynamic organization. I agree that every year the forum has gotten better in responding to people's concerns, as trying to fix glitches. I think every year it's gotten better and better, that the arbitrator pool has gotten better and better, that the process has gotten better, that the discovery has gotten better. So I think that FINRA itself will morph into, I think, a kinder, gentler, more transparent organization. At least I hope so, under Rick Barry. And we'll have both. We'll have the best of both worlds: a great arbitration forum and the ability to litigate those cases, like in particular Ponzi scheme type cases that really belong in court.
Thank you, David.
Well, 5 years from now, I think it will remain mandatory. I also think that the average FINRA arbitrator will be in his mid-70s and maybe retired. The PIABA, the Public Investors Arbitration Bar Association, recently came out with a study, a very in-depth study, and found that the average arbitrator is a 69-year-old white male. So 5 years from now, he may not be around. To think about what's going to happen in 5 years in FINRA's program, look back at the past 5 years, I think. They've significantly updated the discovery guide for parties. Boy, that was such a horrible headache. It was such a pain going through the discovery process until FINRA came out with a discovery guide, which they also improved last year to cover product cases. Look how they improved the arbitrator's guide, which is online, and for their own arbitrators to do a better job. In the past 5 years, all public panels are now the default. If a customer claimant doesn't want an industry person on a panel, the claimant doesn't have to have an industry person on a panel. The other thing which you'll see in the future, the past couple of years, FINRA's introduced and enhanced its online portals with the goal of making them the standard for all cases, to eliminate paper. A week or so ago, Rick Barry, the new Director of Arbitration starting next month, announced that FINRA's policy now is paperless. So we'll see that. And I think lastly, the fact that they established that special task force is a reflection of FINRA's desire to distinguish itself from mandatory arbitration systems that don't afford due process and that are, as I call, forms of adhesion.
Thank you, and I'll have the last say. I actually agree with many of the points here, so I'll be very succinct. I agree the Commission has to do something, even though Dodd-Frank doesn't say that. I think politically it's untenable. They've had a pass up to now because they've had mandatory study and rulemaking requirements, but it's 3 years later, or 4 years later almost, and they're going to have to do something. At least a study. I do think in the next 5 years, I hope I'm wrong, but if past is prologue, there'll be another crash and or product failure. It's just, as David said, look back 5 years, it just always happens. That will cause another increase in filings at FINRA, and I think will cause there'll be a public arbitrator shortage. So there's going to be a real focus on having enough arbitrators, as Rick Ryder and others have already pointed out. I agree. There'll be many more cases done online, on the cloud, certainly smaller cases. I think the idea of someone packing up and going somewhere is very quaint and anachronistic, but it just doesn't make sense in today's world. I actually agree with something Melanie said. I think eventually the Arbitration Fairness Act in some iteration is going to be enacted. It's not necessarily blue state, red state. It's kind of a populist issue in places like Alabama and the Dakotas. And as I said, proposed in one of my articles, I think the choice will be given to investors, but I think before the dispute, at the time the contract is signed, not after, which I think is very difficult. We'll see. We can do this again in 5 years, and we can compare notes because this is all being recorded. So those are my predictions. Let me turn to our concluding section here. I want to thank our panel and the Securities Arbitration Commentator, which to me sounded like a great program. You'll be the judge when you listen. Mike, Melanie, and David, great job. Thanks to anyone who's listening. Again, we do think training at some point will become mandatory, and things like this podcast are a good way to educate panelists and constituents. Be sure to follow some of us on Twitter. The Twitter handles are posted here. Now, our next podcast, which will come later in the fall, we're going to make believe. We like this theme of let's make believe. We're going to make believe we're sitting down and having a cup of coffee with Rick Berry. Congratulations, Rick. Rick's going to be the new Director of Arbitration at FINRA. We're going to make believe we're sitting down having a cup of coffee and saying, look, for what it's worth, here are our views about the challenges facing the FINRA Arbitration Forum. That'll take place sometime later next month, later in the fall, and you'll hear more about that going forward. Thank you again for participating, and thank you for following the Securities Arbitration Commentator. Good day.